Ladies and gentlemen, our next session is a panel discussion today on legal challenges in real estate development, something I'm sure all of you want to know about. It's moderated by Mr. Reddy with panelists who are fantastic, like Mr. Prashantha Kumar and Mr. Jayaprakash Padmanaban. Now, let me tell you a little bit about each one of our panelists as well as our moderator. Mr. Reddy is the chairman and managing director of the ARC Group. Under his leadership, our group has executed notable residential and commercial projects in Hyderabad and in Bengaluru. Mr. Reddy has served as founder president of CREDAI Telangana, and he's currently secretary of CREDAI National. He is a dedicated philanthropist. He supports youth through the ARC Foundation, and he promotes a Sattvic lifestyle on his 180-acre farm. He's a good friend to make. Now, let me introduce you to our prominent speakers from Fox Mandal. Mr. Prashantha Kumar is a seasoned legal expert with over 20 years of experience specializing in real estate and infrastructure, and his expertise spans real estate transactions, SEZs, EOUs, and regulatory compliances. Mr. Prashantha is also a prolific speaker, and he's a writer. He contributes to legal reforms and industry knowledge, so he'll be invaluable on this panel. Welcome. And Mr. Jayaprakash Padmanaban, he brings 23 years of legal experience, specializing in real estate litigation, title due diligence, and contract drafting for a very diverse clientele. His practice covers finance, joint ventures, debt restructuring, and environmental compliance. He advises policymakers. He serves as an external consultant for Tamil Nadu's real estate regulatory bodies. Please welcome our two panelists and our wonderful moderator with a round of applause and enjoy this session.
Very good morning to all. I think yesterday night everyone enjoyed in Sydney cricket ground. Good to see hall is full, almost full. Very, very happy morning to all of you. Today we are going to have a discussion with two eminent lawyers who are representing Fox Mandal, Prashant and Jayaprakash. So Prashant and Jayaprakash, we have across the country more than 100 cities developers are here today. So the moment you talk about the legal, to me, I don't want to go for any court cases. Never I wish to go, because never when I go to a court, things get, not going to resolve. But at the same time, we have to protect ourselves. So how to protect ourselves? So let us we have 45 minutes of time. So whatever the best can be given by both of you, I think it should be a takeaway for all our developers. Thank you for this thing. So let me first, you have been the real estate, you have many real estate clients you're dealing in Chennai and Bangalore. So what comes to you first? Developer, you have been dealing with many developers. So what are the legal aspects you're dealing? And what are the challenges you have faced? What are the developers who are facing challenges? How did you resolve those things, Prashant?
Good morning. Good morning, India at Sydney. Hope everybody is awake. Good. Thank you, sir. It's a very good question. The questions come to us today. Why legal? What is the role of a legal industry with respect to real estate industry? Here, let us go back, a decade back, how we used to treat the real estate industry and how it is today and how it is going to be tomorrow is something that we really need to be mindful. If I go back, conventionally, real estate was an unorganized sector. Today, yes, government has taken some steps. There are certain enactments. Without our knowledge, it has become a regulated sector. And future, it is going to be a highly structured industry. It's going to be a highly structured industry. That is what we are aiming for. See, most of the people, they understand why legal, what is legal. Chalo, I'll go to one of the council, I'll get some title opinion done, and everybody start feeling that, yes, my legal is done, I'm clear. Legal assistance is a journey. It is not something that 10 piece of paper signed by a council and he says that, yes, boss, you are ready to go, your title is clear and proceed. No, that is not. See, let us understand. I know that a lot of designatories are here, and I see that some of the people under some startups also come up. It's a crazy combination here who are sitting here. So what I say is, and actually all your seniors know the value of legal assistance in the real estate journey. So let us see that actually if somebody wants to understand what should be the scope of a legal in the real estate industry. It starts, any legal will not get into sourcing of the land. Any legal is not into it. And after sourcing of the land, what happens? What kind of a challenges we are facing? Because
Before sourcing only, we have to, to identify a property, then we come to you.
that's what I say is an actually identification of the property you do. And beyond that, you will come to us say that, yes, this is what I have identified. What challenges we see? See, what happens is, I want to tell to everyone here in India, ownership, what we enjoy is a presumptive ownership. There is no absolute ownership in India. How do you ascertain ownership? There are two ways. One is what we call it as a by title, and second one is by possession. It means that a person who is having the document to show that he is a owner, and the person who is enjoying the possession of a land who is a owner, then I ideally say that, yes, this person is a owner of this land and you can proceed it. That is where the basic scrutiny starts, how a land has been, how he has acquired a land. What are all the actually title issues he have? From whom he has acquired? Is it a freehold, or is it a grant land, or is there any restrictions that are there in the title? From there, slowly it starts. Let us say that we have surpassed the stage one is to establish a clear and marketable title on the land parcel. That is a stage one. That is where you are also ready. Yes, my land is ready, so I can make an investment on this land and I can proceed. Then what next? Most of the people stop here. Why I am telling again and again? Because today it's a regulated industry and tomorrow it is going to be a structured industry. From here the journey starts. From there we start actually developing. What is your model of a business here? What is that you are going to do? Are you going to construct by your own capital, or are you inviting a capital from the outside? Are you going to raise a loan for it? Yesterday we saw that actually some of our banker friends, when they are speaking that no, legal document is very crucial. I need a developer to furnish me the legal document. Without that, I will not be able to help them. Same is the situation is going to be. Your allottees and your purchasers will say that, sir, without document, I don't want to purchase it. And if you are managed to sell also, again, they will come and the regulator will come. Why did you sell? Without document, I will not permit you to operate. So here the question is, having a clear file and having a clarity on the title is very crucial. The stage two is what kind of a documents we are entering into. With your investor, with your banker, with your allottee, your journey starts from there. So we will help you, we will assess you, we will assist you and tell you that what you need to agree and where you need to disagree. This is very crucial. See here, because I always say that any agreements that are created, I say that agreements are created by your friend, but read by your enemy. Please understand that agreements are created by your friend, read by your enemy. So be mindful what we are signing. So till you complete the project, we need legal assistance.
Very good, Prashant. Agreements are prepared by your friend and read by enemies. Really, it's a good takeaway. I think we all should look into that because normally once the agreement is done, generally we go on signing that. So, Jayaprakash, I think, so what exactly the developer has to look into details when a property we are buying or going for a joint development?
Right.
So even after getting the due diligence also, a lot of complications are coming up. Even the properties which are purchased from the government also, we are facing the legal challenges.
Right.
So what exactly, you just go into deep into this and what a developer has to look into that.
Good morning, everyone. First of all, congratulations to CREDAI team for pulling this wonderful event. And our association with CREDAI goes long way back. So I'm very happy that I'm sharing this dais with you people. To answer your question, from a legal perspective, what I look at, right? So a developer comes and he actually has a vision and he comes to me saying that this is what I'm going to develop, right? So when I look at it, marketable title is very objective, right? So we keep hearing good title, marketable title, absolute ownership, these kind of terminologies we keep hearing. So on that, title is something is very clear, right? Title, you need to actually go through the title records, which will be corroborated by the possession by way of revenue record, okay? Every lawyer who does that job, he will do it. More or less, if they have that kind of integrity and if they have the knowledge, mostly 90% will actually do a similar kind of deliverables. But where the objectiveness of this legal scrutiny comes is, what is marketable? So marketable is very different for each client. Somebody who's coming to me saying that I'm going to invest in land, right? For him, marketability is very different. Okay, he's going to hold on to that land for next 10 years. He is going to actually get the capital appreciation. For him, marketability is completely different. Somebody who is going to come with an idea of doing an institution, his marketability is very different. What he has to look at is how he is going to get his affiliation done by the university or whosoever is the affiliation agency, whether that property will actually suit that requirement. Similarly, for co-living, for commercial, for residential. So understanding this is the first step when we interact with the client. So when the client comes and says that, okay, this is what I'm looking at, we need to understand what the client's objective is. That will drive your diligence exercise, right? That will drive the marketability. So when you say marketability as the conclusion, you have an introduction as well in your due diligence report saying that the client intends to do this purpose for which he is engaged me to do the due diligence, right? So there it starts. So it is very objective and subjective according to the requirement of the client, what they are intending to do. As long as legal professionals, we are able to understand that, we will be able to deliver what it is required. Because now reports are not only title search report, it is a project report. So for example, the regulatory compliances, for example, there are buffer zones, right, CRZ.
No, in Hyderabad, we are facing such a big challenge where the permissions were granted by some authorities. Now they have found it's in a buffer zone.
Right.
So, I mean, government is giving the notices and some places already
Absolutely,
demolished.
that's exactly
So,
what I'm
no,
saying.
I mean, how do we have to protect? I mean, developer has gone for a permission. I mean, even a customer with a proper permission is there, RERA registry is there, people purchase the property. Now some authority comes and says this is illegal. So how to protect? What developer has to do in this case?
So we are looking at two things. Where you have acquired a land where already there is a notified buffer, or if the buffer zone has been declared subsequent giving a
Both the cases are there.
retrospective.
Both the cases are there.
So retrospective effect, we don't have a control on that. So that you can only challenge by way of writ on, again, if it is against public policy, you can actually file a writ and you can get some kind of resolution to it. But if it is already there and you have missed out to actually do that, for example, archaeological department, okay, they have notified areas, right? If you do your due diligence on the specific land, you will never find it out, right? Because the buffer zone is 100 meters restricted and 300 meter regulated, right? It will never reflect in your due diligence on that specific field numbers, okay? So once you acquire and go for the development, only then you will get to know that this is what it is. So similarly, multiple regulations are in play. What we focus as title report is only the title and the revenue part of it, right? Unless and until the professional whom you are engaging or who is advising you has this whole idea. It's like now, it's like a jigsaw puzzle with 200 pieces, right? A professional who has a fair idea of how this works has the reference picture.
So the legal
Before we
person.
get into the next question, I would also like to add
No, I'm
whatever
not going for
GP
that. I'm
said.
continuing
No,
to that.
no, same thing. What I said that I got your question. One thing what you said that actually if there happens to be a restrictions and which you are not aware, which the government has approved it. Let us take an actually a classic case of Maradu case, what happened in
Yes.
Kerala.
Yes, yes.
Okay. Here, the government has actually given
No,
an
even it's in occupied for people who are staying for 3, 4 years. Everyone was occupied. Then Supreme Court gave
So
the
one
judgment
few
to.
things we need to understand. The first concept is law of the country. Law is above everyone. Okay. There is also under law, we have one more concept called promissory estoppel. It's an actually a doctrine of
No, but now what is the sanctity of the permissions then?
that is what. Actually, what happens is, and actually here, you believed that yes, government has given a permission, hence I am entitled to use this. The people relied on the government permission and they said that yes, this is something which has been ratified, rectified, sanctioned by the government, no issues, they also purchased. But someday the government realizes or some of the people, the activists realizes this is something against the existing zonal regulations. Your usage is not permissible. When we answer this question and at the first also I said that it's a journey. Journey we need to understand the nature of the land, and in the nature of the land whether the usage for which you are going to have the project under law, is it permissible or not. So here the question is, just because one of the authorities has given you the sanction as against the prevalent law, that cannot be taken as an actually a model.
But that normally, I mean, due diligence means generally we go for legal due diligence. This buffer zone and all, most of the lawyers, I don't think they will go into such details. Most of the lawyers, I can
We
say,
should.
maybe, I mean, firms like yours, maybe, but when authority has given, it's not some authority, there's a proper authority who has to give the permission. In Hyderabad, the cases are happening now. I mean, HMDI given the authority, I mean, permissions. Now they are sending the notice, they have sent the notices to the properties. So, how the developer or the purchaser, I mean, is securing from this?
No, no, I know this is a very big confusion, and what happens is here, can we claim the card of innocence? Can we claim the card of innocence, or can we claim the card of bona fide purchaser when it comes to the land development? Answer is no. You say that you are expected to know the law, you should have done as per the law. If you have gone against the law, just because one of the authority has given a permission, I cannot grant it. One thing, what happens is Maradu case is, and actually the Supreme Court has found that authority is equally in fault with the developer, and they have asked authority to also compensate to the allottees. Here, the who is liable for this? They have jointly held liable, both the developer as well as the authority.
Yes, it is unfortunate what you are saying is right. The accountability has not been actually pinned on the authorities who has given the approval. So though the court is reprimanding them, though the court is actually giving harsh comments against how they have done it, but your question is when everything has been complied with and in future something is actually found fault, right? Is there, then what is the sanctity of the approval, right? That's an alarming question.
Yes,
That's an alarming question, yes. Whether we have an answer to it legally to say that, no, this is not possible because the apex court has given this order. So we may not actually comment, we may not be able to comment on that. Yes, at every level we are actually saying that the administrators and the authorities are not made accountable for their actions. That is something which needs to be judicially
That has to be
scrutinized.
this. I mean, every time, even RERA also, we were requesting yesterday Minister about to bringing the authorities also into the RERA purview so that, I mean, they take the money sometimes, they guide us in fact, I mean, sometimes some cases, they guide the developer and do the wrong things.
Absolutely.
So ultimately, everyone is facing the problem. So, I mean, what are the other challenges we are going to face? I mean, there's one thing, we give an example. Generally, I mean, what are other ways to look at in the protecting the property? Maybe purchase, we started the project, and in midway, in one of our project, one landlord's sister filed a case, suit on that. So, I mean, of course, again, some negotiation happened and we resolved it. But what are the things to look into that?
Sure. Here, so as Prashantha rightly told that we follow the doctrine of caveat emptor. So that means that buyer should be aware of what is the risk involved in that transaction. So we follow the doctrine of buyer beware. Buyer beware, caveat emptor means the purchaser should be aware of what he is getting into it. So we follow that doctrine. The defense is available in Transfer of Property Act if you are a bona fide purchaser, putting reasonable effort in identifying the issue, and in good faith you have done the transaction. Yes. So that is your only defense available, right? This is where the due diligence on the asset makes it very, very critical. What kind of efforts? Because most of your issues on legal are common, right? You are only banking upon, client comes to us saying that, okay, you do the due diligence, I've identified some 10 issues. I say that, okay, this 10 issues, you need to take a commercial call. Client will ask that, JP, what commercial call means? You need to advise me. What kind of, how confident are you to actually defend this position, right? Every lawyer you go, we only bank upon limitation. Other than limitation, we don't have anything else to say that how we could actually defend this position, okay? Limitation, again, it is a very leniently viewed position because the limitation triggers from the date of knowledge of that person. So this is where the issue crops up. This is where the limitation has been condoned leniently by the court, so that is where all this problem happens. So 40 years back, somebody else has done something. He only need to show prima facie, right? I have not actually noticed it. I have applied for encumbrance certificate. I found this discrepancy. The cause of action starts from the day I applied encumbrance certificate. A suit is filed. He may lose the suit, but it will actually go for 5 years. Till 5 years, you cannot actually hold on to your project. You are forced to settle him. So, okay, this is the issue, right? To avoid this, diligence is very, very crucial, where what and all actions you need to do as a part of diligence. There used to be a situation called, when we do a diligence, first thing what we do is send a requisition on title, written requisition on title to the seller. He has to answer it, sign it, and give it back to us. That practice is not widely followed now. Okay, this is the first thing where we get a written response from the seller saying that, okay, these are all the statements he's making. Okay, then you need to definitely give a paper publication. I'm talking about the steps what you need to take to mitigate these scenarios. Okay, you need to give a paper publication. And then you need to do your other searches, personal searches, you need to do this. So if you do all this, and if your due diligence report is going to have all this content, right? Tomorrow if there is an issue, then you are taking the defense of bona fide purchaser. Whatever needs to be done from your end, you have already done it. So your interest should be protected. So that is the defense you are going to take. So this would be my advice, saying that if you do a due diligence, do a proper due diligence. Don't cut corners and actually say that I need the report in 2 days' time. Whatever you find it, give it. That should not be our demand.
Just to add
So,
on
I mean, timing is running.
No, no,
out,
I
think.
want to share a few things as actually to your this question. See, you raised a very important thing, that actually sisters filing a case. Yeah. We need to understand, as I told that actually, we need to understand the nature of the land here. I just brief you in 2 minutes. What is the difference between a self-acquired property or a family property or an ancestral property, joint family property? Here the very crucial, because most of the Indians, we follow Mitakshara school of law, which actually gives a right. A child in the womb will have a right on the property. We need to be very careful when we are dealing in ancestral property. 2004, that is the 20th December 2004, we brought one amendment to the Hindu Succession Act, where we have inserted 6A of the Act, where we said that all the daughters are co-personaries. So it means that actually all the daughters will have a right in the joint family property or a co-personary they can claim. So whenever we are dealing with a co-personary property, it is very crucial that you include everybody in your conveyancing document. See here, construction of the document is very crucial. Lot of courts will get into it that why the karta of the family or the manager of the family is selling this property. So in your recitals, we need to mention very clearly what has been provided under the enactment, that for X purpose, he is selling on behalf of all the co-personaries, on behalf of the minors, because the minors will have a special right. So we need to be very careful when we are dealing with an ancestral property. But when we are dealing with a self-acquired property or a self-owned property, no-brainer. we can deal. But here we need to understand, if somebody claims that
So how many years you have to go back? How many generations are rather, again,
this is a
how many generations?
classic question. See, a lot of people say that, sir, you are doing a title due diligence, how many years you want to do? See, we always consider 30 to 35 years only based on the limitation. Article 112 of the Limitation Act says that the limitation for the government possession, where government can have a claim, is a 30 years. Based on that 30 to 35 years we do. Otherwise, actually, a lot of people say that, sir, we will go to the source. Source where? Wherever after the British Raj ends, whenever the revenue administration has started, from there we will do it. And second thing, when it comes to define what becomes an ancestral property, we have a 3-degree test. It should have actually passed 3 generations. Any property that has crossed 3 generations, that qualifies to be an ancestral property.
Thank you. So, I mean, Jayaprakash, I think regarding the RERA, quick answers, I think time is running out. So, we have a defect liability period for 5 years. So, from the property sold or handed over to the customer. So, I have a project where I sold 90% of my units in the, I mean, before handing over, and 10% of the units I sold after 5 years. So, the defect liability starts from after the 5 years?
Yeah. Unfortunately, the construct of the language reads like that. Section 14.3 of RERA says that the limitation is from the handover of the apartment to the allottee. But there is some kind of, the legislative intent doesn't seem to be like that. Legislative intent is to have this 5-year as DLP from the date of completion. However, it has been, I would say that, loosely constructed, where it gives an impression saying that if you are going to sell the last apartment after 10 years later your completion, so your defect liability period goes to 15 years. Because it is structural, even one apartment if you don't sell, right? So this 15 years will benefit will go to the entire structure.
So the entire 15 years we have to maintain.
Correct. But only one state has actually done, recognized this and done a rule amendment. Telangana has done a rule amendment. Very fantastically, they have captured saying that the defect liability period, not on this extent they have not done it, but the defect liability period for your OEMs and consumables. They have brought in clarity saying that for OEMs,
So
the defect liability period will not be there, and manufactures this thing. But this timeline, I think, yes, there is no legislative jurisprudence on this. It has not been tested. But if it tests and the court gives an interpretation that 5 years from the date of handover, or there should be an act amendment. As on date, it is 5 years from the date of handover of the apartment.
Prashant, can you throw a light on NCLT? So, I mean, many companies are going to NCLT. Why? How NCLT is?
In a very, I know that actually we have a time constraint.
Yeah.
We know that actually the purpose of NCLT and the purpose of RERA are
No,
two.
which company? How the NCLT comes into?
So that's what actually, what happens is actually NCLT is actually we know that this is an enactment which has been basically enacted for the retrieval of the companies. And second one is to save the most of the creditors. That is the intention of an NCLT. But as we evolved, 2016 when these two enactments has came, the entire scenarios of the real estate industry has also changed. See, one of the orders when it has been passed by the RERA that has been now treated as an admitted liability on the part of the developer, there lies actually a cause of action where people started preferring a petition before the NCLT under Section 7. But after noticing it, the government has also come up with a regulation which says that there should be a threshold limit who can actually prefer a NCLT. So they have stated that the 10% of your allottees, all the 100 members, whosoever is lower.
So in a project, I mean, suppose 100 units project, 10% of the people
Yes.
together
Or 100 members, whichever is lower.
But IBC has evolved now. Recent regulation says that project-wise CARP is possible. That's a major shift from how it has been looked at. IBC, one interesting thing happening is generally the parliament will have the law and the judiciary will have the interpretation of law. Here what happens is because of the void gap what IBC has not covered, judiciary is actually giving the direction to the policy makers to actually do it. So project-wise CARP is a judicial move, reverse CARP is a judicial move. There is no regulation as such to it now.
So thank you, friends. It's already time out. I think let's on a wonderful session.
Thank
I
you.
think our people are. I mean, they're both are very very experienced people. So offline you can take the any questions. I think many questions are there from the especially from small developers.
Definitely,
So
definitely.
thank you so much.
Love
Thank
to
you.
catch up with all of
Thank
you.
you.
Thank you, NatCon and NatCon organizer for giving this prestigious opportunity. Thank you. Thank you all. Have a great day.
Thank you so much, gentlemen, for shedding so much light on the legal challenges. I had no idea it was that complicated, but made easy. Thank you for that explanation. And I'm sure your expertise is going to help people with a lot of their complexities currently. I invite Mr. Um, Shivarama Kumar Malakala and Mr. Faizan Siwani and Mr. Vinay Ranganathan on stage to felicitate our panelists. Thank you, everyone.